Hey everybody, how you doing? Very excited today to be joined by employment attorney Erica Domingo. Erica, thanks for taking the time.
Absolutely, Bill.
So we're here today. You probably have seen in the news the bombshell that was dropped by the Washington Post on Friday about the Washington NFL football team and the years of sexual harassment allegations. We wanted to bring Erica on as she has experience in handling these types of cases. I have some questions. I'm sure you guys have some questions, and we're hopeful that Erica's knowledge can answer some of those. So Erica, obviously this was big news. What are your first impressions about these allegations?
So I'm not surprised to see something like this. We're talking about an NFL football team where it's a male-dominated field. Unfortunately, this is the perfect type of environment where sexual harassment is going to occur. Now, these are just at the allegation stage. We don't know, nothing's been proven yet, so we don't know if any of it's true, but certainly when you have a group of this size of 15 women coming forward, it makes you think there's probably some truth somewhere in there.
So we're here in South Jersey, which is obviously a big Eagles town, big Philadelphia Eagles supporters. So I wanted to talk to Erica. How do you feel in general about the Washington NFL football team?
Well, first of all, go Birds. But the Washington team has had problems for a long time. They've held on to a problematic name that embodies a discriminatory word or term for our native people for a long time, and a lot longer than they really should have. So this is just another piece of Washington problems coming out and being brought to light.
Yeah, that name, it was a long time coming. Thankfully, they finally have decided that they're not going to use that anymore. And I think you're right. This has been something that has shown, is this indicative of who Washington is as a company? I mean, ultimately, that's what they are. The Washington football team is a company, and to utilize a name that was so discriminatory for so many years. And in fact, I think Dan Snyder was quoted as saying he will never change the name. Well, that's obviously changed, but is that evidence of a bigger problem there?
Absolutely.
So Erica, one of the things I read in the news was that the Washington football team has hired outside counsel to investigate these allegations. Now, could there be any conflict of interest there? Could Washington attempt to influence this outside counsel's findings at all?
Well, certainly there is a concern that there's going to be some kind of influence or undue prejudice. You have to remember, when we look at these things, I appreciate when an organization hires outside counsel to investigate because you hope it'll be unbiased, but they're still being paid by that organization. So there's a question about whether the findings are going to be favorable to the organization so that that outside group can maintain their job, get work from that organization in the future.
So Erica, the Washington football team has stated that they plan on changing some of their HR policies going forward. Now, is that something that can be viewed as an admission of guilt? And then taking that one step further, in the civil context in court, is that admissible?
So I'm not going to say whether this will actually come into court and what happens in the Washington proceedings. We're in New Jersey. The rules may be different in DC, but one of the things that we look at as employment lawyers is they're making these changes. Maybe it's not an admission that something was wrong, but certainly it can go to show that the policies that they had in place at the time the harassment occurred were not strong enough to prevent it. And thus they've made better policies or stronger policies because now they see there's more they could be doing to prevent it from happening in the first place.
So Erica, what do you expect this investigation to find?
Bill, the allegations we're looking at here present as a classic he said, she said, or in this case, he said, she said, she said, she said, she said, because we have 15 accusers talking about the hostile work environment, the sexual harassment that occurred. So when I'm looking for a good investigation in the workplace, I don't want just to see an investigation of talking to the accusers and talking to the victims, because they're going to just present two diametrically opposed positions or stories or versions of what occurred. I like to see where an investigation includes outside witnesses, other employees who maybe are not implicated in any way in the investigation, and see what they saw, what they heard. And that's where you're going to find the truth of the severity of these allegations, the truth, whether this did happen, whether it didn't happen.
So Erica, the allegations in this case span over the last 13 years. Is that something that's uncommon in a case of this magnitude?
13 years is a long time. In New Jersey, we have a 2-year statute of limitations on allegations of sexual harassment or discrimination, but there's something called a continuing violation doctrine, which is where if the allegations are ongoing for things keep occurring over and over and over, it can span back further than 2 years. 13 years is a long time, but that doesn't mean those claims may not be brought in as part of the case.
So when the Washington Post article was released and this story hit the media, both the owner of the Washington team, Dan Snyder, and the former president, Bruce Allen, have indicated that they were unaware of these allegations or this behavior prior to this report coming out. Now, is that something that's common when you have an organization of this size?
It is common. Typically, you'll hear that those higher up in an organization were unaware, or they'll allege they were unaware of what was going on, just because how are they keeping track of everything that happens going on every day? And if the allegations were never reported to human resources, there is a possibility they were unaware. Although my understanding from additional information that has been released on this story is that the named plaintiff in the lawsuit alleges she sat in very close proximity to one of those two individuals, so she would be very surprised if they were unaware.
15 women to date have come forward and have alleged sexual harassment allegations while working for the Washington football team. Do you expect more victims to come forward as this goes on?
Bill, with an organization of this size, I would not be surprised if more people do not come forward, more women come forward. Probably former employees, you'll see people who left, maybe people whose allegations are untimely for filing a court proceeding, but they are part of that, what we call Me Too evidence, which can be brought in a court of law to show that this was a pattern or practice of the employer that was going on.
You referenced Me Too. What is Me Too evidence, Erica?
So we know the term Me Too has kind of come up in the past couple of years as a pop culture phenomenon of women who are supporting other women who have been victims of sexual harassment. But Me Too evidence in court talks about other allegations, same kind of idea, that have been brought forth that tend to support a victim's claims or a plaintiff's claims in a civil lawsuit. So if there's other people making the same allegations against the same harasser in the same period of time, that can be brought in even if that person has not brought their own claim.
Obviously, Erica, we focus on New Jersey and Pennsylvania law, but in general, what type of damages can the victims in this case seek?
Typically, the main damages that can be awarded to plaintiffs in employment discrimination or sexual harassment cases are called compensatory damages. They are comprised of both lost wages and money for emotional distress. If an individual has sought some kind of mental health treatment as a result of what happened to them in the workplace, they are entitled to be compensated for that. In addition, if a judge or a jury finds that the conduct of the employer was particularly egregious, where it was a willful blindness, turning their blind eye to what was going on in the workplace, they can also award punitive damages, which are meant to punish the employer for allowing this kind of conduct to go on in the workplace.
In addition to the victims in this case seeking damages, can a case like this also have an effect on the internal policies of an organization?
Typically, a change in policy is not something that a court will order in these cases. Sometimes if there are allegations that are brought to the Equal Employment Opportunity Commission, or EEOC first, the EEOC can order an employer to provide training or improve their policies. But in a lawsuit, that's typically not ordered by a judge or by a jury. But our hope as employment lawyers is always that the work we're doing and bringing these allegations forward and making Washington see what they're doing wrong will effectuate change in some way and will create better policies so that the workplaces are safe environments for everyone.
So, Erica, my understanding is cases like this mostly resolve before a trial.
That's true, Bill.
But if this case was unable to resolve and it had to go all the way to a trial, I mean, what type of impact is all of the negative press surrounding the Washington team over the last few months, between the name change to the minority owners selling their ownership to FedEx indicating that they refuse to sponsor the team if the name doesn't get changed. You know, how is that going to impact the ability to get an unbiased jury to hear this case?
It's definitely going to be difficult to impanel a jury down there in DC. You know, one of the questions that's asked in jury selection is about biases and if you have a bias for or against any of the parties. So if you're a diehard Washington team fan or you really don't like them as a team, those people are not going to be able to sit on this jury because they're already prejudiced in one way or another. And it's going to be hard to pick people to sit on this jury for sure.
Erica, thanks for sharing your knowledge today. I mean, it's very important for people out there to understand their rights as employees. Discrimination, harassment, it needs to end. There's no place for it in any workplace, whether you're a small company, a big company, it just needs to stop. So thank you, Erica, for putting this out there so people can understand their rights.
You're welcome, Bill. I totally agree. And I hope that this video maybe will inspire people to come forward and not be afraid to fight against a big employer or any size employer if these illegal things are going on in the workplace.
Absolutely. Thanks again, Erica. Have a good day. Talk soon.
You too.